Good evening and welcome to the Public Governance, Performance and Accountability Act. My name is Danette Fenton-Menzies and welcome to this evening's webinar. What I'll do is I'll go through the overview of the particular PGPA Act, and then at the end I'll open it up for questions if you have any. I hope that's okay. So what we're going to be looking at tonight, if I can get the slides to work properly, there we go, is we're going to do an overview of the main parts of the Act, and we're going to look at what you need to know in relation to the PGPA Act, and then talk about your obligations. So for those of you that were used to the Financial Management and Accountability Act, there are some new duties that come to you as officials under this particular Act, and so you need to be aware of those. Now in terms of this Act, it basically received royal assent in June last year, and it came into force from the 1st of July this year. All of the Commonwealth Authorities and Companies Act was repealed, but a little bit of the FMA Act was left in place. It's going to be given a new name, and that bit was to do with drawing rights. So I'm not quite sure why it wasn't included in the Public Governance, Performance and Accountability Act, but it wasn't. But the bit to do with the drawing rights is in place basically till 1 July next year. Now in terms of how the Act is set out, there's 112 sections and it's broken into 4 different chapters. So the first chapter is basically the introduction, includes definition sections, etc. Chapter 2 is for Commonwealth entities and the Commonwealth. So basically any of the old Commonwealth authorities and also any of the FMA agencies. Commonwealth companies, which were the second part of the CAC Act, the Commonwealth Authorities and Companies Act, have their own separate chapter, Chapter 3. And then Chapter 4 covers things such as the rules, the delegations, and the requirement for an independent review of the Act and the rules after 3 years. Each chapter within this particular Act is broken into parts and divisions, and you'll get a copy of these slides, and so if you click on that link it will take you to the actual PGPA Act in Common Law. Now the objects of the Act, Section 5 basically tells you what this particular Act is about, and one of the reasons it was brought in was to establish a coherent system of governance and accountability across Commonwealth entities. So under the previous framework we had 2 separate Acts, the FMA Act and also the Commonwealth Authorities and Companies Act. Both of those Acts had put different requirements on people within those organisations. So this Act seeks to have the same requirements across the different types of Commonwealth organisations. Part B of the objectives is basically to establish a performance framework across Commonwealth entities. So one of the things when they were reviewing the old framework was comments made by a number of people that it was difficult to actually tell whether we were performing well or not. There was a lot of focus on financial information, not a lot of focus on non-financial information, and people struggled with, is the organisation doing well or not? So they're going to establish a performance framework. Now this is the second part of the implementation, so we won't see a lot to do with the performance framework till the 2015-16 financial year. Currently they've got a draft performance framework out there which is going through the consultation phase. So we expect to hear more about that in probably November or December this year. Now Part C is to require the Commonwealth and also Commonwealth entities, of which your organisations will be one, to meet high standards of governance, performance and accountability. And it's just like the name says, public governance, performance and accountability. That's the main focus of the Act. We also need to provide meaningful information to Parliament and the public, which will include non-financial information when we get to the 2015-16 year and we're working under the performance framework. We also will need to work cooperatively with others to achieve common objectives where practicable. Now what that bit's in there for is because as government shrinks, we will be expected to work more with not-for-profit and private sector organisations, and also we always work with other jurisdictions as well, such as state and territory governments. The final requirement in the objectives of this Act is to require Commonwealth companies to meet high standards of governance, performance and accountability. So they're a separate type of organisation called Commonwealth companies, whereas the old FMA agencies and also the Commonwealth authorities are regarded as Commonwealth entities. Now in this Act, under the old FMA Act, the definition section was Section 5. Under the new Act, it's Section 8. And this is where any of the new terms that you hear in this Act will be defined. One of the things, I've been teaching the new Act for a couple of weeks now, and one of the things that people struggle with is just the new language in the Act. So let me take you through some of that new language. Section 10 defines a Commonwealth entity, and that includes a Department of State. So if you're if you remember the old FMA CAC flip chart, if you were one of the 19 departments of state that were in the yellow section, then you're a Department of State. So departments like agriculture, industry, they're departments of state, immigration as well. Or if you're a parliamentary department, you would also be regarded as a Commonwealth entity. So departments such as the Department of Parliamentary Services. Part C is listed entities. Listed entities are actually listed in the PGPA rule under Schedule 1, and they were all of the other ones that were on the FMA side of the FMA CAC flip chart. So they come under one of the departments of state and make up the portfolios. Part D is the body corporates, which are established under a law of Commonwealth. These were the old Commonwealth authorities. The body corporate, basically with a Commonwealth authority as they used to be called, they were created by their own piece of enabling legislation. For example, the CSIRO is a Commonwealth authority, or used to be a Commonwealth authority. So there's a CSIRO that creates the separate legal entity called the CSIRO. So the difference between the old FMA and CAC was that with an FMA agency, and say we use the Department of Industry, they would sign their contracts, Department of Industry, on behalf of the Commonwealth of Australia. Whereas CSIRO, being a separate legal entity to the Commonwealth, would sign their contracts simply CSIRO. So the first three were basically what used to show on the FMA side of the flip chart, and the last one were the Commonwealth authorities on the Commonwealth and authorities side of things. Now, under Section 11, there are two types of Commonwealth entities. The first one are called Corporate Commonwealth Entities, or CCEs, and these were the equivalent of the old Commonwealth authorities. There is a couple of ones that used to be FMA that are now regarded as Corporate Commonwealth Entities, and most of you will be working under what we call the non-corporate Commonwealth entities, or NCEs. So they've dropped one of the C's in the acronym. So they are the equivalent of the old FMA agencies. So Department of Finance has actually issued a new flip chart which shows you those, and I'm just going to change screens, so hopefully this works for you, and I'll just show you what that new flip chart looks like. So hopefully you can see this on your screen, which is, again, it's a two-sided flip chart. The blue bit are your non-corporate Commonwealth entities. Your green bits are your corporate Commonwealth entities, and the yellow ones are the Commonwealth companies. There is, like the old FMA CAC flip chart, there is symbols and colours explained on the second page. So that's just to give you a look at what that's like nowadays. That is available in the same place that it was available if you used to print out the old FMA CAC flip chart, which we'll go to a little bit later on. Okay, let's just get our slides back up. I love it when things don't work. Hang on, there we go. All right, hopefully you can see the slides again. So for most of you, you will have worked in what we previously called an FMA agency, and that is now called a non-corporate Commonwealth agency. Under the old Act, we used to have what was called a Chief Executive, which was generally the head of your agency, but because we referred to the Chief Executive instructions under the FMA Act, the head of an agency was called the Chief Executive. Under the new Act, under Section 12, they are now called accountable authorities. An accountable authority can be a person, such as a secretary of a department, but for some organisations they will have a board or a council. So the people on that board or council and the head of the organisation would be regarded as the accountable authority. So instead of having chief executive instructions or CEIs, you will now have accountable authority instructions or AAIs. And that's important because accountable authorities have specific duties that you need to be aware of because you will be supporting them in your role as an official of the organisation. Now, all of you will be regarded, if you work in the public service, as an official under this particular Act. The only people who are not regarded as officials are ministers, judges, consultants or independent contractors, unless the PGPA rules say that they are an official, and also an individual class of individual where the rules say they are not an official. But generally, most people will be regarded as an official. Why that's important for you is that there are specific duties that apply to you as officials. And for those of you that previously worked in FMA agencies, these are new duties, so you need to be aware of the changes in the duties. Towards the end, there's a slide that actually takes you through the names that we were used to under the FMA and also the new names under the PGPA Act, so hopefully that'll help you too. Now, Part 2.2, Division 2, basically talks through the different duties of the accountable authorities. I'm going to go through these briefly because they will be things that you assist your organisation with achieving. Section 15 is really important because this requires the accountable authority to govern the entity in a way that promotes the proper use and management of public resources for which the authority is responsible. Most of you will be used to the old efficient, effective, economical and ethical, and that basically has remained with this new Act. They also need to promote the achievement of the purposes of the entity, and finally they need to promote the financial sustainability of the entity. So for those of you that were used to, when you were spending money, talking about Reg 9 and Reg 10, they were FMA Reg 9 and Reg 10. We no longer have them, although we have some equivalents of those, which I'll talk about a little bit later. The bit about financial sustainability is basically giving the head of the agency the requirement that they need to ensure not only financial sustainability for this financial year, but moving forward. So they need to put policies and procedures in place that will ensure that financial sustainability in the future. And we'll come back to that a little bit later on. Another new requirement on the agency head is that they must establish and maintain an appropriate system of risk oversight and management, and also appropriate systems of internal controls. Now, internal controls are your policies, procedures and systems. All of these are designed to protect your assets and also your accounting information. So at the end of the day, we need to assist our organisations, and it does include both managing consultants and independent contractors. Even though they're not officials, this section requires that we manage the risk and the internal controls, and they may be part of that. There is, in fact, sorry, if I go back to that last slide, there is now a new Commonwealth Risk Management Framework which has 9 elements and compulsory elements. So I would imagine in your agencies you will see some new guidances around risk over the next little while. Some other duties that we may be required to assist our accountable authority or head of agency with to ensure that we cooperate with others, and others include private sector, not-for-profit and also other jurisdictions to achieve common objectives. We need to make sure that we manage our risks associated with any requirements we impose on others, and also the effects. So Section 18 is about trying to reduce the red tape that we impose when we're working with others, such as private sector, not-for-profit and also other jurisdictions. Section 19 was in the previous Act, duty to keep responsible minister and finance minister informed. And Section 20 allows that the rules, so these are the PGPA rules, may prescribe matters which help the accountable authority to discharge their duties. Now, for those of you who work in a non-corporate Commonwealth entity, which is our old FMA agencies, they have to make sure that they govern in a way that is not inconsistent with the policies of the Australian government. So for those of you who do procurement or spend government money, we need to make sure that we continue to comply with all of those policies around procurement. For corporate Commonwealth entities, which are your old Commonwealth authorities, the Finance Minister can put particular requirements around those Australian government policies on particular corporate Commonwealth entities. Section 23 is really important because it allows the head of the agency to basically enter into or vary and administer particular arrangements, including contracts, agreements, deeds or understandings, including MOUs. Another thing that the accountable authority can do is to set up a advisory board, and this is just for the non-corporate Commonwealth entities. Those people on the advisory board don't have to be public servants, and they're there to assist the accountable authority to help them with their governance of the particular organisation. They also have a number of requirements as the accountable authority around planning, performance and accountability, and we'll talk about those a little bit later on. Now, for us as officials, because I always include myself as an official given I work pretty much every day with the public service, we covered in Part 2.2, Division 3. So some new duties. These duties were in the old Commonwealth Authorities and Companies Act, but they weren't in the FMA Act. So these are new and ones that I suppose you just need to understand the requirements. So we have a duty of care and diligence. We have a duty to act in good faith and for proper purposes. There are duties in relation to our use of position and use of information, and there is duty to disclose interests. Now, these particular ones I'm going to go into more detail on the next slide, but I just want to make you aware that if you breach these particular duties, what can happen is that you can be punished or dealt with under Section 15 of the Public Service Act, and that's the one which when you breach the Code of Conduct you get consequences from. So it can include things such as termination, demotion, also fines, etc. So it is really important that you become aware of these particular duties, you make sure that you meet these duties, and you'll notice on this slide I've included a resource management guide which I've suggested to every organisation that I've been teaching this particular act in that everyone read. It's called Resource Management Guide 203, General Duties of Officials. This particular guide takes you through what are okay behaviours in terms of meeting these duties and what would represent breaches in relation to these duties. For any of you who deal with the Certificate of Compliance or what is now going to be known as compliance reporting, we will have to answer questions around people meeting these duties from the 1st of July. So I suggest all of you have a good read of that particular resource management guide. It's only about 16 pages long, so it's not too bad. So in terms of what is expected of us when we meet these duties, a duty of care and diligence, we basically look at what would a reasonable person do if they were asked to do the task that we're doing. And if a reasonable person would do what we did, then we've met the duty of care and diligence. If a reasonable person would do far more than we did, then probably we haven't met this particular requirement. For example, if someone asked me to spend $1 million and I worked in public service and I'd never done any training about procurement and I didn't take the time to read the accountable authority instructions and any departmental policies, if I didn't read the Commonwealth procurement rules, and I really didn't pay much attention and made a pretty hopeless effort at spending that money, so I spent it but didn't do it wisely, then I probably haven't met the duty of care and diligence. The second duty, to act in good faith and for proper purposes, we need to look at what would an informed person deem to be an action that is appropriate. So again, if I'm doing it for the right reasons, I'm doing it and I've acted in good faith, then I'll be fine. But if perhaps I'm doing it for my own purposes rather than for the department's purposes, I could find myself in breach of that section. Any time where we misuse our position or misuse information that we have access to in our work roles, and that causes detriment to either the organisation you work in, the Commonwealth, or any other person, then you can be found in breach of either the duty in relation to using your position or using information. The final duty in relation to these is the duty to disclose material personal interest. So if you own shares in an organisation and your organisation's going out to the market to procure things and you're part of that procurement team, then even if you don't own a material amount of those shares, I would still be declaring those. if you're unsure, should I declare this interest or not, it's probably best to declare, and then your organisation can decide what to do with it. So don't forget that resource management guide. Now, some other things that you need to be aware of. So I've already spoken about the fact that if you breach those duties on the previous slide, you can get picked up under Section 15 of the Public Service Act. It is still possible that you may also receive consequences under either administrative law, civil law, or if you've breached bad enough from a criminal perspective, there is still the possibility of going to jail. Now, some additional consequences you need to be aware of relate to a couple of different things. So you personally, or a minister personally, may be liable if you incorrectly gift something. So if you don't meet one of the requirements of Section 66, then Section 67 requires that you personally must repay the Commonwealth the amount of the relevant property that was gifted incorrectly. So an example of this, I had an agency I dealt with where some staff were retiring. The manager basically said to the staff, look, those mobile phones you have, they're pretty old, you know what, just take them when you go. Now, those assets hadn't been written off the asset register by the write-off delegate, and they hadn't been signed off as a gift by the gifting delegate. So in that case, that particular one would be a breach of Section 66, and that would mean that if that was investigated, that particular manager would have been made to pay the value at the date they gifted those particular mobile phones, the value they were worth at that date. Probably not very much, but still something you don't really want to get yourself into if you can help it. Two other times where you might be required to personally pay for things that are lost are under Section 68. If we lose relevant money, which was our old public money, or relevant property, which was our old public property under the FMA, and you didn't take reasonable steps to prevent the loss, then you may be required to pay the Commonwealth out of your own funds. The other time is if we lose relevant money or property where you weren't the person who was holding it or given it, but you contributed to their loss through your misconduct or by deliberate or serious disregard for reasonable standards of care. So if that's the case and someone else lost it, but you contributed to that, you may be asked to pay part of that as well. So pretty harsh consequences if we don't get that right. So they're the breaches for you, or the consequences of the breaches for you as officials. Now some of the other requirements, and just briefly I'll go over these, are some new ones that are coming in. So from the 15-16 financial year, accountable authorities will require or will be required to prepare corporate plans for their entities. As always, we've been required to prepare budget estimates, so that hasn't changed. However, a new requirement is that they must now cause records to be kept that properly record and explain the entity's performance in achieving its purpose. Now that will come in from next financial year when we will actually be doing performance reporting on top of our financial statement reporting. So Section 38 also is part of that, that they must measure and assess the performance against achieving their purposes, and from the 2015-16 year, as I said, they will need to prepare annual performance statements. They will be part of the annual report, and they will focus far more on non-financial reporting. So it'll be qualitative data. So, you know, how do we go? We gave you this money. What was, you know, the outcome of the actual thing that we gave you the money for, and what was the quality of what you achieved? The other thing that has changed under Section 41, we always were required to keep proper accounts and records for financial information, but the wording has changed, so they now are focusing on financial position. So that will mean, and it links to the financial sustainability duty that the accountable authority has. So financial position is the difference between our assets and our liabilities. So I suspect agencies will focus a lot now on what are you doing with your assets and making sure you get the most out of your assets, and what are you doing to control your liabilities. So one of the big liabilities is staff entitlements such as annual leave and long service leave. So I suspect agencies will be scrutinising that and making sure people go on leave on a regular basis and not accumulate too much leave. Section 42 has always been there to prepare annual financial statements and making sure that they're audited. Each agency needs to have an audit committee, and the annual report needs to go to the responsible minister, usually by the middle of October. New one is Section 34, which requires that the Australian Government may publish a statement setting its key objectives and priorities. Where it does that and it relates to your agency, we would generally be gathering information to report back to Government on that. As I said, a new requirement is we will be required to produce the annual performance statements, and in certain instances the Auditor General might be required to actually audit those annual performance statements. So we'll know more about that once the performance framework is embedded next financial year. As always, we still need to give the Auditor General our annual financial statements. The Finance Minister also has requirements. These were in the previous FMA Act, and that is to prepare the monthly whole of government financial reports, and also once all of the agencies have done their financial reports and had them audited, the Finance Minister has to prepare annual financial consolidated statements, which are audited by the Auditor General. Now, I didn't go into a lot of detail on the next little couple of bits, just to give you a summary of the main requirements that you need to be mindful of. So Part 2.4, which goes from Section 50 to 72, covers the use and management of public resources. And I've just defined public resources down the bottom from Section 8 as relevant money, which used to be public money, relevant property, which used to be called public property, and our appropriations. So where you deal with funding and expenditure, that's Division 2. Banking is Division 3. Division 4 covers borrowing. 5 is investments. Now 6, for those of you who are used to contingent liabilities, that's where we find the information on those. So they still exist. So if you are hiring a venue or you are signing any other terms and conditions or contracts other than the Commonwealth, we need to look at the requirements around contingent liabilities. So what it is, for example, if we hire a venue, generally most venues won't use Commonwealth contracts, so we have to use their terms and conditions, and there's usually a clause that says if you burn down the building or someone injures themselves while you're holding your particular event, that by signing to their terms and conditions you agree that you will take on the obligation, you being the Commonwealth. So where that's the case, we have to assess the risks of those particular contingent liabilities, and in some instances seek additional insurance. So all of your agencies will have particular policies around contingent liabilities, and you will need to continue to follow those. Division 8 and Division 9 basically apply to ministers more than you as individual officials. Now, if you're dealing with appropriations, you will find that in Part 2.5. If you're dealing with other jurisdictions and sharing information or putting requirements around audits, you'll find that in Part 2.6. And if you deal with Commonwealth companies or new corporate Commonwealth entities, which are our old Commonwealth authorities, they're dealt with in Part 2.7 and also Chapter 3. The last chapter in the Act is to do with it covers the rules, the delegations, and also there is a requirement on the Finance Minister to, after 3 years of the Act and the rules being in place, that they need to ensure an independent review of them. So that will take place in 3 years' time. One thing just to note in the 4.2, your Chief Executive, or what is now known as the Accountable Authority, they issue their delegations under Section 110 of this particular Act. So hopefully one of the things you've noticed if you've been exercising delegations since the 1st of July is that they no longer say the FMA Act, hopefully they say the PGPA Act. Now, some things for you to consider, particularly if you're working in a finance role, but even if you're not, just generally, is that we need to make sure that all of our internal policies, procedures and delegations in departments now refer to the PGPA Act rather than the FMA or the Commonwealth and Authorities and Companies Act. Given the new obligation on accountable authorities around managing risk and looking at internal controls, now is a good time to go through your policies, procedures and also your systems to make sure that they are actively managing risks. To do with that is also having a look at the Commonwealth Risk Management Policy, which is available on the Department of Finance's website. One of the things I am also suggesting is that if you give out assets, particularly portable and attractive ones such as laptops and mobile phones, given the requirement now that if people don't take reasonable care, they will be required to repay out of their own money, so own salaries and wages, for the replacement of that, I would suggest it's probably a good time to update the sign-out form that you give when people are issued with assets, so that they are aware that they could be personally held responsible if they don't take reasonable care to protect those assets. For any of those of you who are dealing with the head of agency, obviously making them aware of their new duties as an accountable authority. For those of you that deal with the Certificate of Compliance, there is going to be a new report called Compliance Report, and the Department of Finance has issued a draft for that particular compliance report. It applies obviously from 1 July this year, and the questions in that reflect the new duties in the PGPA Act. So if you do deal with the Certificate of Compliance previously and you're going to be dealing with the new compliance reporting, I would suggest you have a look at that draft now, and that's again available on the Department of Finance's website. If you are dealing with staff that are not aware of their new duties as officials, then now's probably a good time to inform them of those duties. As I said, you will get a copy of this particular recording, and if you need copies of the slides, you're more than welcome to contact me. And you can just send that to learn@magicallearning.com. Now, I just want to show you where you can find more information, so I'm just going to move away from this slide. I'm going to come back to the slides in a second just to take you through the difference. But just in terms of, there are two places you can look at. So the Department of Finance has this website, Public Management Reform Agenda, of which the new Act is part of that reform, and it's the start of the reform. Next year we'll be seeing the performance framework put in as part of this reform. So this is here, and it has a number of resources including copies of the Act, guidance, etc. Also, for those of you that are used to using the Department of Finance's website, we still have the Financial Framework tab, and you can click on there and get that CAC flip chart, but the new flip chart. For those of you that want to find more of the policies to do with the new Act, they're not actually under the Financial Framework, as you can see on this bit in this square. So you can click on there and it will take you to the Resource Management Framework. If that disappears at any stage, the other way you can get to it is to click on the Procurement tab, and I'm just going to show you how to do this. And you'll see here under Procurement on the side there's a tab called Resource Management, and when you click on that, it takes you to this website, which is part of finance. I will say for each of these components of the legislation and the rules that you can see I'm flipping on, there are sections. You'll notice there is a See More. If you don't click on that, you may miss some resources. So just be aware that's there, and obviously copies of the legislation and rules are available there too. Okay, we'll just go back to the slides, and I'm nearly finished my presentation, then you can ask questions in a second. So hang on and we'll get that back up. Sorry, just technology. Here we go. Woohoo! Now, just in terms of terminology that you may be used to, if you were used to FMA Act and FMA regs such as 910, we now talk about the PGPA Act and also the PGPA rules. Our Chief Executive instructions are now called Accountable Authority instructions, and because of that your Head of Agency will now be an Accountable Authority rather than the Chief Executive. Instead of being an agency now, we will be an entity, and for those of you who work in the old FMA agencies, you are now known as non-corporate Commonwealth entities, or NCEs. For those of you that may have worked in a Commonwealth authority, you will be called a corporate Commonwealth entity, although if you worked in a Commonwealth company, you will still be a Commonwealth company. Now, the following bits are our old Reg 9, Reg 10 and the ones to do with contingent liabilities. So what was known as FMA Reg 9 is now PGPA Rule Section 18. Now what you'll probably see in your agencies are that the process is exactly the same as it was before 1 July, and you'll probably hopefully have something that says PGPA Rule Section 18, but then hopefully they've put in brackets formerly known as Reg 9 so people know what they're doing. That's the one where we're approving the spending proposals. For those of you that dealt with the old Reg 10, which was making sure that we could approve future year spending, that is now Accountable Authority Instruction 2.1A Authorisation. Hopefully again they put brackets behind that saying formerly known as Reg 10. For those who deal with contingent liabilities and Reg 10A under the old Act, that is now PGPA Act Section 60. The other change that you will note is our Commonwealth Grant Guidelines are now Commonwealth Grant Rules and Guidelines, so they're CGRGs. The Commonwealth Procurement Rules are still the CPRs, Commonwealth Procurement Rules. The other major change is public money and public property are now referred to as relevant money and relevant property. Now there is a heap of resource management guides, and I've just put the ones that are currently available on the next couple of slides. So some of the ones that would be important to you is certainly the one about 203, General Duties of Officials. When we get to the non-financial information, 209 will be useful. You'll notice that there's gaps between some of these numbers. Some of these are still in draft form. So when they're released finally, those numbers between 205 to 209 will be filled out. There is also some around banking and investments, the stuff to do with committing relevant money, so this is where we want to spend money. Some of this is still in draft, but I have at least got the numbers for some of these. From one that, for those of you that deal with suppliers, 416 is an interesting read because from 1 July for payments where we're paying suppliers under $10,000, the government's going to generally encourage us to pay using payment cards such as credit cards. So that's probably worth reading and having a think about how you're going to do that from 1 July next year. The last lot have to do with property management, so if you deal with any of those, and that's a big property, then there's some resource management guides. And for those of you who deal with risk, I absolutely would encourage you to have a look at the Commonwealth Risk Management Policy. It's not very long, but it has 9 elements that are compulsory, so it's important to have a look at that as well. So that's the end of my presentation, and we've still got a couple of minutes left. So I was going to open the floor and ask if you've got questions to feel free to type them in the chat box, and I'll endeavour to answer them. So if anyone's got questions, please feel free to put those questions in. So you can either do it in the chat box or in the question box. I can see both, so fire away. It doesn't look like anyone's got any questions. Wow. So you will all get a copy of these slides plus this presentation, so you'll have a recording of this, so you'll receive a link. If you have any questions at all, please don't hesitate to contact us. We're more than happy to help in relation to this new legislation. Please know that Finance has still got some of these guides in final draft, so not everything is finalised yet. So you may notice in your agencies that some of your policies, procedures still might refer to FMA, and Hopefully they'll get updated shortly, but you will see changes to your processes as we move through the public management reform agenda. So good luck, and as I said, if you need any help at all, please don't hesitate to contact us. We're also running, for those of you who might want to attend, we're running some workshops next week in relation to this face-to-face too, which are a little bit longer than the webinar. So hopefully it's been helpful tonight, and thanks so much for attending. Thank you very much, Kai. I just saw the thank you there. And I hope you all have a lovely evening, and I'll catch up with you all soon. Thank you very much. Bye-bye.